8:19 KTRS. We're broadcasting from the First Rule Film and Broadcast Studios at University Tower on the Big 550 KTRS radio. You can certainly download the app, and don't forget to sign up for Breaking Text at 84126. You can watch us at stltoday.com. Look for the opinion tab, and you can also watch us at ktrs.com. Bob McCullough, St. Louis County Prosecuting Attorney, joins us. Good morning, Bob McCullough.
Morning, McGraw.
Morning. You wanted to join us this morning to give us a update on what's going on with the grand jury case with Officer Wilson. So I will give you the floor. What is the latest?
Well, here's what I really wanted to do. There's so much misinformation out there that when something occurs, then a lot of the talking heads kind of put their own spin on it and put that out there as gospel. So I thought it was probably important to come out and tell people exactly what is going on. I can't talk about the specifics, of course, the specific witnesses testifying or what they're saying, but a couple of issues. One is that the grand jury everything is done by statute. The legislature decades ago enacted the statute that allows for a grand jury and the procedure to pick a grand jury. And that procedure, in a nutshell, means that a judge selects the grand jury in a random fashion. It's all laid out in the statute, and so it's not a tool of the prosecutor's office. We have no involvement in the selection process of the grand jurors. We don't even know who's on the grand jury until the judge sends us the list shortly before they start. This particular grand jury started their term in May of this year, and by statute, the full term of a grand jury is up to 6 months. Typically, the judge will set the term for about 4 months, and that's what was scheduled to end in early September of this year. And so we judge to extend that term to the full 6 months, which is what took it to November. And again, by statute, the court can then extend even that 6 months by up to 60 days. And in an abundance of caution, she also extended it that 60 days, which is where that January date comes from. Now, nobody anticipates, and of course the grand jury can only hear finish what they started. So they're not taking anything new. This particular grand jury is hearing only evidence relating to the Michael Brown, Darren Wilson case. So nobody expects this to go to mid-January, but in an abundance of caution, we have the maximum amount of time just in case something does come along that may delay it some. Now, we anticipated that it was going to go to about mid-October, and the way things have been going, it is probably going to go longer than that. But I suspect at this point we're looking at late October, early November, possibly even a little longer than that, because we're working with the schedule of the grand jurors. They hadn't anticipated going beyond the September date either, and so we're working with that in order to get everything and everyone in. There's an enormous amount of evidence that's being presented to the grand jury that, in most cases, wouldn't happen, but because this case is so significant in our communities, certainly, there are a lot more people coming in to testify than might otherwise be. And so, as I've said before, anyone with information who saw all or part of what occurred in Canfield has been invited to the grand jury to come in and testify, or subpoenaed, whatever needs to be done to bring them in and testify. And a couple other issues that are kind of out there. One is that excuse me. One was about the charges themselves. There's this misperception out there that we're not going to do anything. We, being the prosecutor's office, aren't going to do anything. We're not going to suggest a charge. What I've said is that the grand jury will have the entire range, just as a jury would in a trial. They would have the range in a situation like this. What would be submitted to that jury would be murder first degree, murder second degree, perhaps voluntary murder, depending upon the evidence, and voluntary manslaughter and involuntary manslaughter. And this grand jury will have all of those options. It's not that we're just throwing everything at them and letting them make a decision based on whatever they think. The law will all be presented to them too. That's part of our responsibility to put all the law in there. And then finally, the evidence itself. Everything. If there is an indictment, this grand jury decides that an indictment should be filed, then the evidence will, of course, be released throughout the prosecution, as any other case would be. There are rules, there are statutes, there are rules of evidence, ethical rules that dictate how that evidence is released. If there is no indictment, then that's when I have said that I will release that information pursuant to an order of the court. The court will issue an order that allows us to release that evidence, that testimony, so that it is all there for anyone and everyone to review and to find out exactly what happened and all the information that the grand jury had. So, as I said, I expect it to take a lot more. It's taken more time than we thought it would because of the number of witnesses coming in and the schedules we're trying to arrange. But I just thought it was important that the public know we are proceeding with this. This has been ongoing. Not a week has gone by that we haven't presented evidence to this grand jury, and not a week will go by that we don't present evidence to them until it's all completed.
Bob McCullough is our guest for a couple of minutes, joining us here, and I know you can't answer questions specifically about this, so feel free to say no, but I'm going to ask you anyway. Was this grand jury already seated and got it, right? This was an already seated grand jury, correct?
Yes, this grand jury started in May, started hearing cases in May. And their last scheduled meeting was for, I believe, September the 10th. But it was important enough that this case gets started and we start presenting that, and that we have a grand jury that could hear only this. Otherwise, it would take a much longer time. So they heard some evidence beginning in early September while they were still in their regular session, and then once September 10th came along, then they were finished with everything else. A new grand jury started, and this is the only matter that this grand jury is hearing.
You've also said that there are two people in your office, one of them being African American, that you've told us before that were sitting in the chairs when the rotation came up. How much direct involvement and day-to-day involvement do you have with this grand jury?
Well, I have not been in front of the. I met with the grand jury before any evidence was presented to them to talk about here's the process and here's where things are going to go, or how the evidence is going to be presented, what we're going to do. It's going to be recorded, and we'll work around your schedules. But the two prosecutors I've assigned to that, one who had the homicide duty on August 9th, and the other who is in charge of this grand jury along with their other responsibilities, are the two presenting all the evidence to the grand jury.
Can you tell us the racial makeup and the men and women makeup of the grand jury?
That is out there, and the judge released that information. So there are it's a grand jury of 12. There are 3 African Americans and 9 Caucasians, and I believe it's 7 and 5, 7 men, 5 women.
Okay. Go ahead, Kelly.
You were just saying that, if there is no indictment, that you will probably release this testimony for people to see. And that's pretty rare, right, to do that?
It is rare. It's very rare, but and there's no probably about it. It will be released. But yes, that's very rare. Well, for 2 reasons. One is generally everything in the grand jury is closed. Now, if an indictment comes out in any case, then that grand jury testimony is, of course, admissible in the trial. And in this situation, generally, if there is no indictment, not just this situation, but if there's no indictment, then it's a closed record. It's a closed record unless the court orders that it be released, and we've asked the judge to do that, and the judge has agreed that she will do that. If there is no indictment, she will authorize the release of the testimony and the physical evidence that was presented to the grand jury.
Have you had any conversations with Governor Nixon at all, and any about whether or not he was going to take you off this case?
No.
None whatsoever?
No contact, no.
Okay.
Nothing at all.
And then lastly, Bob McCullough, lots of people only know the law from cop shows and lawyer shows on television. So you coming here is sort of to help explain it all to us. But there's a philosophy out there that a prosecutor can get any indictment through any grand jury. Speak for a moment about that, and how is this being portrayed? Is it being portrayed more as a here's good evidence and here's bad evidence, here's all the evidence? Is this a normal grand jury? Are you going for indictment? Do you normally go for indictments? Explain that process.
Well, we generally, and let me address the first part of that first, is that you know, I even saw in an article in the Washington Post some columnist saying, you know, the old saw about a prosecutor can indict a ham sandwich. Well, an unethical, irresponsible prosecutor who presents the evidence in such a skewered fashion can indict a ham sandwich or anything else. However, at some point, that prosecutor would have to stand in front of a judge and jury and prove beyond a reasonable doubt that ham sandwich committed a crime. That's just how silly that argument is. That's part of the checks and balances. You know, nobody makes the final determination. So this case, like every other case, we present as well a lot more evidence in this case because of the significance of the case to the entire community. But in most situations, you know, let's say, for example, it was a homicide case and there's an element of self-defense involved. That information would be presented to the grand jury so they can look at it and make a determination, you know, is there enough evidence here to go forward with this case? Not is the guy guilty or is this a complete self-defense situation, but is there enough evidence to present this to a trial jury and do that? And that's what we're doing here, but with substantially more evidence and substantially more live witnesses, so that the grand jury gets a full feel for this case. And in effect, just about everything that is presented to this grand jury would be presented at a trial should there be an indictment.
Are you?
And I think that's important because because all that evidence is there for this particular case. So they're basing it upon everything they have. And the only thing we're not presenting or won't present is something that would be absolutely inadmissible at a trial. And that's just, you know, again, that's improper. We can't do that by the statutory and the ethical rules.
Are you working in conjunction with, independently of, and having any communication with the federal investigation that is going on?
We have a lot of communication with the federal authorities on this, both the U.S. Attorney and the FBI. And essentially, what we have, they have, and what they have, we have. Now we're going in looking at all the same evidence, but there are different statutes that we deal with. They, I'm sure, have no idea. Well, the U.S. Attorney does because he used to be a prosecutor, but knows what elements are necessary, what evidence is necessary for any level of murder indictment. But I certainly have no idea what it takes to prove a civil rights violation. So that's what they're looking at, and we're looking at violations or potential violations of the state law.
Bob McCullough, thank you very much for your time. Bob McCullough, County Prosecutor.
Anytime.
You got it. Thank you. Bob McCullough joining us here to clarify some information and some misinformation that was out there. He said that the grand jury will be finished probably late October, early November. Mm-hmm. He said that the grand jury will be given all of the charges, whether or not they'll be given murder in the first, murder in the second, violent manslaughter, involuntary manslaughter, voluntary manslaughter, and it'll be up to the grand jury to decide, and that all of the evidence will be presented. No conversations with Governor Nixon.
And what evidence they have, the federal authorities have, whatever federal authorities have, they have.
And the racial makeup is 3 African Americans to 9 whites, and it's 7 to 5, 7 men, 5 women.
And what the evidence that they're listening to now, that's all they're focusing on right now.
Right.
They're not working on any other cases, the grand jury.
The grand jury, and which was already seated.
Right.
And yeah. So there you go. Interesting stuff. We will, if you missed any of it, we'll have it up and out on KTRS.com, and we'll also send out the full interview so you can follow us, 550 KTRS, and also on our Facebook page as well. 8:33.